Hello, everybody. Welcome to another installment of A Rebel Without Applause, coming to you as I always do from my little nutshell of infinite space right here in the wood of the holly under the sign. And coming to me across this slender digital divide from from Silver Spring, Maryland, is a professor. He's originally from Long Island, and he is an expert on all things constitutional. He lives at the very pinnacle of the academic life. He went to Dartmouth, Yale, and Columbia, and now he is a professor of law at the University of Maryland. And he is a distinguished historian. He is a prolific writer and thinker on all things constitutional. And he's the author of a book called Punish Treason and Reward Loyalty, the Forgotten Goals of Constitutional Reform After the Civil War. He's here today to talk about what has for so long been ignored, and that is Section 3 of this 14th Amendment. Welcome, Mark. How you doing?
Doing well. Thanks for having me.
My pleasure. So I know you, I feel like you have two sort of identities, and that's a law professor and also a historian, and so we can switch hats as needed. But firstly, I'd like to go back to that most perilous moment in December, I think, of 1865, when the 39th Congress convenes in Washington, and there's a whole slew of unreconstructed Confederates waiting to take their seats. And tell me about that moment and how it sets the stage for this most important amendment and then later Section 3.
The fascinating moment in American constitutional history, and one we never study, in part because it has some radical implications we'd rather just tamp down a little bit. The Secretary of the Congress calls the roll. You may have seen this in the proceedings with Speaker McCarthy, over and over again calling the roll. And at the end of the roll call, a number of people, raise their hands, say, you forgot me. I don't do a good Southern accent, so I won't try, but I'm the representative of Alabama. And the Secretary said, no, I didn't forget you. You do not come from a Republican state. We do not recognize your election. And so all representatives and senators from the former Confederate states were excluded from the 39th Congress. The very end, Tennessee got back in, but they were excluded. And this means the 14th Amendment, as well as the Civil Rights Act of 1866 and the Freedmen Bureau Bill, Second Freedmen Bureau Bill of 1866, were passed only by representatives of the states that remained in the Union during the Civil War. Now, some of these were slave states like Kentucky, but only Union states were allowed to vote on legislation and constitutional amendments after the Civil War. And
that, sounds a little bit undemocratic, but one of the things that strikes me about that historical moment, that it took, what some might say undemocratic means to forge and create a new democracy.
Well, it may depend a little bit on what you mean by undemocratic. As Republican leaders said, we didn't kick them out. They kicked themselves out.
Correct.
They refused to accept the result of a democratic election. Before they come back in, we want to make sure they're committed to respecting the results of democratic elections. And in many ways, that's what Republicans really wanted. We focus a lot, and for good reason, on racial equality. But in fact, simply preventing secession, ensuring people would respect fair democratic elections was as important, if not more important, to them.
It's funny as you talk about that, because I'm a sports fan, and every weekend we watch the football scores. And, my team, the Rams or the 49ers, they might lose or they might win. And it might be a really bad call that, determine the end result of the game, and people can scream about it. But we're all trained to accept the result. We don't riot after a game. We accept that result and go on to the next week. But somehow, I guess in the election that brought Lincoln into office, and the one that just preceded us now, people didn't accept the results, or a big portion of them didn't. And I feel like sports, in a way, trains us to accept the results, even if maybe in some people's eyes they're not fair.
Well, we have a notion, and you had to bring up my team, which I'm loyal to, the New York Giants,
Oh.
and we get very used to losing. And sometimes with clubs that are cursed, you lose an official decision, didn't go the way you thought it would. But the idea is, if you agreed on the pre-existing rules, touchdown counts 6 points, extra point is 1. You think the officials were doing their best. Then in a democracy, you have to accept the results. This is what Lincoln says in his message of July 4th, 1841. In a democracy, once the ballots are counted, there cannot be a recourse to bullets. So once, you fight hard, you fight fairly, but on the assumption the game was fair, even if there were mistaken calls, those are the rules. And a constitutional democracy means playing by the rules.
Right. And by the way, if you don't accept those results, there's no league, there's no NFL. It can't exist. And I just feel like it's an apt metaphor, but I don't hear it a lot, but it feels very apt to me as we talk about this.
I'll add, people say constitutional rules are constraining, and some may be, but as you point out, many of those rules are enabling. Unless we have the rules of football, we can't play football.
No.
Unless we have rules that say, here's the president, here's how we make legitimate laws, we can't make legitimate laws.
And if you're not willing to abide by that core covenant, then you can't play.
And that's Section 3.
Exactly. So I saw your debate or conversation with the folks at the Federalist Society, and I think there's a tendency when you look at especially Section 3 to kind of go into the arcane meanings of the word officer, or whatever the legalese is. But as I read it, it reads very clear. It's almost like, if you had a driver's license and you got drunk and you got arrested for driving drunk, we can't really give you a driver's license again until there's some penalty. And this doesn't feel that different to me, in terms of just as a very clear warning to anybody.
I think that's right. And in fact, I am going through newspapers in 1866,
Mm-hmm.
and all of them say, yep, the meaning is you revolt against the federal government, you can't hold federal office, that there are no technical words in Section 3, or none were intended. It's not like there's a letter of marque and reprisal, which, when I ask my classes, every now and then there's a student who's been in the Navy who knows what a letter of marque and reprisal is, but none of them know. But anyone can read Section 3 and figure it out. If you engage in an insurrection, you were a former office holder, you're disqualified.
Right. Now, as you mentioned earlier, there was this, we think of the Civil Rights Act, and I just want to, I want to backtrack for some of my audiences, because when we refer to the Republican Party, we're not really referring to this Republican Party of today. Republicans, and specifically the radical Republicans of that moment, were the party of emancipation, the party of Lincoln, and to a large extent, the party of abolition, I guess, in the few years prior to the Civil War. So the labels have changed a little bit. I want people to just be clear about that, for those of people that aren't, immersed in this history, because I think one of the things that you do is important is there's this academic to academic kind of communication, but I also feel like the culture level of civic understanding is pretty low right now, and I to the extent that can be raised up a little bit, I think it just might help. So just as an idea of understanding what the Republican Party is or was then and not is now. But after the Civil War, of course, there was the 13th Amendment that was passed, but there was a big need, as I understand it, to codify in law, first with, I guess, the Civil Rights Act of 1866, and then later in the Constitution, to give some sort of legal meaning to this incredible war that had just occurred, that everybody had been touched by, that huge battles have been fought within a day's commute of Washington, D.C. I mean, it's hard even to imagine the level of violence and social disruption that was facing the United States, at the end of 1865 after this war. And so there must have been an incredible urgency to come up with something to give meaning to this victory.
And I like to say the Republican Party is not only opposed to slavery, they're opposed to two other things: the slave system and the slave power. The slave system is all the things associated with slavery: racial prejudice, lack of education because you don't want African Americans learning anything. The slave power is the political apparatus that allows slavery to flourish. Now, Republicans thought with the 13th Amendment, Section 1, they had done away with slavery. They thought Section 2 would allow Congress to do away with the slave power. The slave system. The problem was that once African Americans are free, the 3/5 clause no longer exists. The South gets approximately 30 representatives for African Americans who will be denied the ballot. And the fear was, with that, the 13th Amendment will become a parchment barrier. How can we ensure government by the majority that opposes slavery and the slave system? And the answer is the two most important provisions of the 14th Amendment, Sections 2 and Sections 3. Section 2 says, if you disfranchise any percentage of your male population, you lose that share of your seats in the House of Representatives and Electoral College. So suppose you have 10 seats by population in House of Representation. Half your population is Black, you disenfranchise them, you only have 5 seats.
Right.
And so the idea was, now Alabama gets a choice. If Alabama disfranchises African Americans, it can elect all the white people it wants, but it'll always be in the minority. If it enfranchises African Americans, it's got a chance of joining the national majority, but only if it's fair to African Americans, because African Americans in Congress aren't going to vote for Jim Crow. Right. So in some ways, what Alabama has to say is, okay, African Americans, here's the deal. You can vote. We're not going to do Jim Crow. But what do you think about federal railroad money for Alabama? Now we can have a bipartisan coalition or a biracial coalition. And once you have biracial political coalitions in the South, the framers thought the Civil War is really over. And that we do not have them may say something.
Right. So basically, the 3/5 clause, as long as it's still there, empowers, what you say, the slave power, unless there's something else in the law that guarantees the franchise to the previously, enslaved people. And so that's at its core the basis for what would be the apportionment clause, or Section 2 of the 14th Amendment, which was critical. And it's interesting because, as I understand it, Section 1, which is equal protection, due process, and birthright citizenship, has been sort of the stepping stone for so much of the civil rights progress that we've had. But you go right to the second section of that amendment rather than the first.
What I was doing right before I was talking to you was I was going through newspapers in Connecticut. And simply, Connecticut's the first state that ratifies the 14th Amendment.
Mm-hmm.
And what do the newspapers say? They say, Section 1, yeah, that's already, Congress can do everything in Section 1 already. Nice statement, sure. Section 2, that's what we really want. Their priorities were different than ours.
Right. We didn't. It's hard to project back what they were thinking, or you've done that by your research, and that of course brings us to Section 3, because without Section 3, these goals realistically can't be achieved. It seems to me that the Section 2, is sort of asking for, demanding.
Section 3 has an immediate and a more distant purpose. The immediate purpose is to politically neuter the Confederate leadership, that there needs to be a new leadership class in the South. The more permanent understanding is if you take an oath to support, defend, preserve, an oath of allegiance to the Constitution, and you violate that oath by engaging in an insurrection, you are not fit to be a Democratic representative. Now, notice something very interesting about Section 3 and the way Section 3 differs from some other forms of disqualification of the countries. It says you can advocate whatever you want. You want to advocate a return to slavery? That's fine. You want to say Hamas is wonderful? That's fine. The crucial feature is only when you actually engage in violence. So people talk about Section 3 as preventing the voters from exercising choice. Well, the voters can vote for any policy they want. The crucial thing is the person they vote for has to say, the way I'm going to try to make that policy is by persuading other congressmen, passing laws, passing constitutional amendments. As long as that's the way I'm going to make my policy, the Constitution permits you to advocate any policy, no matter how heinous.
And there was no confusion at that moment or at that time what the word insurrection meant.
Like every other legal word, law professors could find hypotheticals at the margin. But everybody agreed an insurrection had 4 features. Had to be 2 or more people. Some people said a few more than 2, but again, with January 6th or with the Civil War, that's more than 2.
Yeah.
Had to be resisting a law by force or violence. They're very clear. It didn't have to be military. If you were throwing rocks, that was force and violence. If you were hitting someone, didn't have to be overthrow of the entire government. The Whiskey Rebellion, all they were doing was trying to resist attacks.
Mm-hmm.
But there had to be resistance to a law and by force or violence. If you weren't using force and violence, by definition, that's not an insurrection. Last, public purpose. So people resist arrest all the time, and the reason why is they don't like being arrested. So if the mob had gone into Congress for the purpose of getting things to sell on eBay, that's many things. It's not an insurrection. An insurrection has to be, no, you are resisting the law itself. You are resisting the peaceful transformation of power in the United States.
And what could be more central to our governance than the peaceful transfer of power? This isn't the Whiskey Rebellion. They're not rebelling against some other tax or an unfair law. This is at the real core of the whole process, is the peaceful passage of power. Now, I would say this, for example, if John Brown had been a congressman and had did what he had done, he also, I guess by the definition that you had described, would have been under Section 13 prohibited from holding office had he not been hung.
In fact, he was hung for insurrection under Virginia law.
Not federal law. Okay.
Yeah, states also had insurrection laws on insurrection as a crime.
So that in your op-ed, for example, you talk about Jefferson. If this was a law, rather Section 3 was an obstacle for perhaps maybe Jefferson Davis or Robert E. Lee running for the American presidency after the Civil War. I guess there was a realistic fear that could happen.
Yeah. Realistic may be a very strong word. There was a fear. There was a broad scale fear that the South, having lost on the battlefield, would treat politics as, we often says war is politics by other means. Politics is also war by other means. That the strategy of the South would be to regain control of the federal government and do whatever they wanted to do legally. And so preventing Jefferson Davis, Robert E. Lee from becoming president was crucial. Now, maybe it wasn't Jefferson Davis or Robert E. Lee, but preventing a prominent Southern leader who had championed secession from becoming president was at the top of their agenda.
And I guess to some people, Andrew Johnson might have been sort of he was, I guess, sort of an interesting figure because he himself was from the South, and he in his own way seemed to be obstructing some of these ideas and amendments.
Between Johnson and Jefferson Davis. Now, every now and then, Americans being what they are, you're going to hear Johnson is a traitor, this, that, and the other thing, because people who disagree with us on who's going to win the next football game are traitors in the United States.
Right.
But nobody ever suggested that outside of impeachment, Democrats who stayed in the Union, who did not seek to self-consciously aid the South, no one ever suggested that they were barred by Section 3. You could oppose the 13th Amendment. You could oppose racial equality. That didn't make you a traitor, as long as you said, the way I'm going to oppose racial equality is I'm going to form a political party, and I'm going to try and persuade people. Section 3 says, the minute you say, I'm going to achieve my goals by persuading people, you are qualified constitutionally to hold office. If you're using ballots, you're qualified. Bullets, not so much.
And one of the things when I read this amendment, it says if Congress, there is a method to remove the disability, which is 2/3 of each house. So there's a way if you're found, but there doesn't seem to be anything really clear as I read it, how to determine if someone participated in insurrection. It might have been plainly obvious if you'd resigned from the House of Representatives and put on a Confederate uniform, you would participated. But as I read it, there's nothing that clear for me to determine if indeed someone did participate in insurrection.
That was left first to the states to develop procedures.
Mm-hmm.
And then if Congress didn't like what the states were doing, Congress could say, well, we're going to suggest you do it this way. So, the bottom line is they didn't think most people were going to contest. If you were a soldier in the Civil War, you engaged. Your office holding was a matter of past record.
So they didn't feel that there would be much gray area in terms of that, because you'd either held office, taken the oath, and then in those days you joined the Confederacy, you participated, you were either in the government or you put on a uniform. So there wasn't really an overwhelming need to adjudicate that in a court, is basically what you're saying.
There were adjudications when it came up, when people challenged, there were adjudications in court.
And didn't Jefferson Davis himself use this Section 3 as a way to avoid a treason charge, I believe?
The trial of Jefferson Davis introduced the expression hot mess into American constitutional discourse. There were all sorts of issues, among other things. Did he have to be tried in Richmond, Virginia, before a jury of his peers, most of which thought secession was a very good thing? The federal government never got its act together and eventually just let the charges just drop. So there were lots of different grounds upon why they might drop. It doesn't create much law, but mostly it just became politically infeasible.
And then shortly after that, there was a general amnesty, and it sort of rendered, at least for the Civil War, the former Confederates, it sort of rendered that section, as I understand it, it made it moot almost.
The general amnesty did not cover everybody,
Mm-hmm.
but it covered enough people that Section 3 ceased to have much effect.
Now, let me ask you this. How much of, let's say, the rise of Jim Crow and the resurgence of the Klan and, the subversion of voting rights in the South for formerly enslaved people, how much of that do you think, and that tragedy that really continues into the mid-50s and 1960s, almost 100 years, how much of that do you think you can trace to this amnesty that first is, as you say, in 1871, I believe, and was it 1871, the amnesty?
1872.
1872. Okay, so not that long, just a few years. And then I think prior to the Spanish-American War, it's extended for whatever the leftovers. And then finally, even in the 1970s, posthumously, it's the disability is removed for Robert E. Lee and Jefferson Davis. So my question to you is, how much of that, all these amnesties, contributed to the century of Jim Crow and lack of voting, and really just an abridgment of this leap towards biracial democracy in the United States?
So much went on that it's impossible to sort of isolate one factor and say, this factor caused it, or this factor caused 15% of it. The Amnesty Act was coordinated with, in fact, the 15th Amendment. The idea is, okay, now African Americans are able to vote. So what? Jefferson Davis can run for office. He's not going to get the black vote in South Carolina.
Mm-hmm.
Of course, the black vote in South Carolina gets suppressed. So it is a combination of restrictions on the Southern leadership being removed, the federal failure to protect African Americans, in particular African American voting rights, that it is not one thing. It is generally the North got tired of keeping Southern racists down, of protecting African Americans. Other policies or other policies seem more pressing to too many voters. And so people just basically said, we're tired of Reconstruction.
Time marched on, and the Klan did too. And when you look back on that, what I call tragedy of our history, how does that make you feel about today and the current moment?
Well, the problem is reform is never, let's go out and reform today and tomorrow we can forget about it. The efforts for equality have to be ongoing efforts. We can't pass the Civil Rights Act of 1866 or the Civil Rights Act of 1864 and say, we've done it.
1964.
We defeated, 1964, yeah. We've done it. We've defeated racism. This is not to say everything that is being done today to defeat racism is a good idea, but it is to say that status hierarchies in the United States exist. They are strong. They cannot be toppled over with one act, and they require constant vigilance.
That's the lesson to take from those moments. I was reading. I was trying to. Well, when I had a conversation with Kermit Roosevelt, he often, one of his core themes is the founding framers are probably not the people we should be honoring as much as maybe the second founders, as Eric Foner might say, the people like Thaddeus Stevens and Abraham Lincoln and Frederick Douglas. And somebody who's just come into focus for me as I've been reading more about the 14th Amendment is John Bingham, who seems like kind of an unsung hero of that moment as I read about him.
Rod Maglioka has an excellent biography of Bingham. I actually think, well, among the American public, Bingham may be an unsung hero. I think among scholars, Bingham is overrated. And the reason I think Bingham is overrated, Bingham is the person who really focuses on Section 1, the rights. What Thaddeus Stevens and others understood is rights work only when the government is committed to protecting the rights. What they wanted was things like Section 2 and a stronger Section 3 to ensure that Americans would be governed by people committed to racial equality, people committed to national union, people committed to democracy. In the absence of those commitments, nice words in a constitution don't do much.
And we're seeing that at this very moment. And as I look out the window and I see this big orange asteroid heading towards us, this presidential election and this former insurrectionist, what's your feeling about how this? Well, I have two things. It's about what should happen and what will happen. As this Section 3 of the 14th Amendment just reads very clearly to me. But what's unclear is if indeed it will be used, if it can be a guardrail in the present moment. And I know that you, I guess, were an expert witness with this gentleman in New Mexico who was successfully removed from office as an insurrectionist. He, I guess, was a county commissioner somewhere in New Mexico. What's your feeling about where we are now?
Our guardrails are coming off. In part, people have to be willing to use the guardrails. So there were different guardrails of people could have said, Donald Trump, he's a racist. He appears to be a sexual offender. He is a tax cheat. He is a criminal. Yes, he may in office do some policies I like, but I'm sorry, we can't do this. Liz Cheney was willing to do this, but too many Republicans who ought to have known better hadn't. That's a guardrail. Section 3 is another guardrail. It tells justices, do your job, disqualify the person. You're not doing anything for abortion rights. Another pro-life candidate can come in. It's not like the other Republicans are pro-choice.
Right.
And they're not my favorite people in the world, but they're people who seem to understand we go by ballots, not bullets. They are guardrails. They have to say, as Chris Christie is saying, Donald Trump is not qualified to be president. American voters have to say he's not qualified. A country in which Donald Trump is a favorite or a possible favorite to win the presidency is not a country that will survive long as a constitutional democracy.
So there's more than just individuals on the ballot. Now, does this fall into the laps of the various Secretary of States that basically administer elections? After all, it's a state by state endeavor, or our national elections. I mean, what's the practical way? Is this that these guardrails can be actually, used?
In my opinion, subject to, I think, a very important qualification, the secretaries of state are the first people who can set up guardrail. Now, it depends. It's very crucial. Some state laws may say if a 5-year-old comes before you and says, I want to run for president, it's your job to put him on the ballot, even though the Constitution says disqualify. But a lot of states actually permit the Secretary of State to check into qualifications. Assuming the Secretary of State it's their job to say you're disqualified. Now, it's important to emphasize, people say, how can a Secretary of State disqualify a presidential candidate? Well, it's the same way a single police officer makes a decision that someone has committed a crime. When the police officer makes the decision, when the Secretary of State makes the decision, it's not final. All they're doing is putting the ball in motion.
Mm-hmm.
And now, at the end, if Donald Trump wishes to protest, he will get his Supreme Court day. He will get a day in Congress, but somebody has to be willing to take the first step. This has been what Trump has always counted on, is no one wants to be the first to say, this is not a person who is constitutionally qualified for office, either because he is a sex offender, and sex offenders are not qualified in a moral sense to be president, or he is an insurrectionist, and he is not constitutionally qualified to hold office.
So there's I guess it's Michigan and Colorado. There's various situations where these things are working their way up. The court system, where are we right now with that?
Well, there are, as far as I can figure out, 4 places where serious lawsuits have been raised. In Michigan and Minnesota, they were dismissed not because someone said Trump is qualified, but because they said timeliness. The Secretary of State couldn't do this. You couldn't do it at the primary stage. You had to do it some other time. Colorado declared that Trump engaged in an insurrection but relying on a very obscure point, said, but by the way, it turns out a president is not an officer of the United States, which would have stunned people on Section 3. And my sense is stunned the Colorado Supreme Court. That is on appeal. They are considering it. There's a similar lawsuit that there's actually a hearing going on as we are talking in Maine. There may be others going on, but those are the ones that have reached the hearing stage.
Now, I believe Lincoln wasn't even on the ballot in some of these southern states when he was elected, but he was able to cobble together an electoral majority. And none of the states that you've described to me might, well, I guess Colorado could conceivably go for Trump, but there's no, let's say, Southern Secretary of State that has decided to intervene on behalf of this amendment, as far as I can see.
The red states are claiming Trump is qualified, or he shouldn't be disqualified, because the Constitution, people ought to be able to vote for a sex offender, for an insurrectionist, which I think is a mistake. This is what I say, the one person who needs to step up and say the emperor has no clothes. But if there is a Supreme Court decision, now the court can rule Trump is disqualified nationally. And to be honest, I think a great many Republicans would be very relieved if the Supreme Court handed down that decision.
I agree. They would be.
Somebody, it's sort of, we start with a sports metaphor. Somebody has to take the jump shot. You just can't pass the ball around forever.
Yeah, well, Havlicek has the ball, whatever. Somebody's got to take the shot. Well, I hope that person is out there. I mean, you make a very good point about, somebody who's, I believe, under the age of 35. It doesn't matter how popular or brilliant they are. They can't run for president. Or a lot of people loved Arnold Schwarzenegger. He was born in Austria. He can't run for president. So these rules are clear, and it's not always just about, popular will. One of the arguments that was posed when I saw you in the video with the folks from the Federalist Society, or at least the point of view was, well, when there's doubt, let the voters decide. And I guess they were trying to create in their argument that there was plenty of doubt surrounding, the architecture and the intent of this section. What's your response to that?
Notions. First, they're claiming there's doubt whether, it's rather interesting, very few of the arguments have been Donald Trump didn't do it.
Correct.
The claim is there's doubt whether the president or presidency is covered. I've been in the weeds on the 39th Congress, on the ratification conventions. I can't find anybody who expressed doubt. There actually is one person who expressed doubt. He recanted 30 seconds later. So first, there's no doubt. Second, it's not clear, even if there was doubt, which way we should go. Is it more democratic to allow anyone who wants to run? Or is it more democratic to say you only get to run and hold office in a constitutional democracy if you are committed to the rule of ballots and not bullets? There are democratic arguments on both sides. So it's not, the Federalist Society sometimes says it's democracy versus something else. It's not. It's one notion of democracy versus another notion. And they're both reasonable notions. I'll add, by the way, this Supreme Court doesn't seem to believe in democracy when Republican interests are not on the line. We can apparently have a democracy with a lot of gerrymandering. That doesn't bother people. We can, affirmative action gets passed by democracies, doesn't bother people. The court strikes it down. Property laws. It seems to be a great many people on both the right and left, democracy becomes a convenient value.
As needed per the situation and the issue.
Yeah.
Yeah, and that's always being arbitrated and litigated. I mean, there's this huge gap between what should happen and what will happen. One is, more of the predictive science, and the other is, I think, more the realm of what the place that you live in. And so, as you, having lived in the weeds, not only for the 14th Amendment, but Section 3 specifically, as I understand the debate, the original proposal was not only to restrict office holders, but guess what? If you had participated in insurrection, you also couldn't vote. I think that was an original, it was part of the debate, as I understand it.
The original proposal was Section 3 was disenfranchising of anyone who gave aid or comfort or participated in the late rebellion until 1870. There was also a proposed statute disqualifying various people for a great many reasons, among which they thought this was unworkable. They switched at the last moment to a disqualification section.
For office holding, basically. And that's what has prevailed. Well, I'm curious to see what is going to happen. And I know that you're at the center of this. I don't even want to call it controversy, because to me, it's just pretty plain. It's clear. It's like a speed limit sign. It's not a lot of debate when you read it. I didn't go to law school, but it seems really clear to me. And I don't feel like you have to be that brilliant to see what's plain as day. Do you think that in order to effectuate this, that the special prosecutor is going to need a January 6th conviction, or that the committee's findings are enough? I mean, is there some legal barrier that is yet to be crossed that might make it easier to invoke this amendment?
You don't need a conviction. Disqualification is civil, so it's not beyond a reasonable doubt. You don't need a conviction. O.J. Simpson can be found not guilty of murder, but found liable for wrongful death. So, the findings are useful, but Donald Trump is free, and he has every right to demand a hearing on the evidence. It would be very nice to have Donald Trump take the stand under oath and explain just what he was doing on January 6th, before and after. And he has that right. I wasn't there. Maybe we've gotten the facts wrong. But those are what is crucial. What did Donald Trump do on or about January 6th? Not legal technicalities about whether there is some bizarre presidential exception to Section 3.
Right. Now, is there a difference between being on the ballot? It doesn't say you can't be on the ballot, and actually holding office.
Well, one might say all that's barred is holding office.
Right.
On the other hand, it makes sense. Why have people vote for someone who's disqualified? So it seems to me, when the Constitution says states may determine the time, place, and manner of elections, seems to me that means one of the things states can do is decide, are we going to put on our ballot someone who's not qualified to hold the office? And the state can say, no, we're not going to do that.
Right. So what we really need is a Supreme Court decision that will apply to all the states. And these, I don't know, what do you think the timing is, if and when that day might happen with Section 3?
Off this broadcast, look at the news and discover Colorado has disqualified Donald Trump. Maine has disqualified Donald Trump. My sense is Donald Trump isn't going to say, well, I've been a sore loser all my life and I regret that, So I guess I'm just not going to be in the ballot 2 states. He will appeal immediately to the Supreme Court. The Supreme Court, if they have any sense, and here I think they will realize this requires a decision with some dispatch. So ideally, it would be nice if everything was settled before the real primaries started. If you could get things settled by early February, that would be good. The
Right.
court is capable of doing this.
They did it for Bush Gore.
Yeah.
And years ago, I wrote a script called Ballot Box 13 about how Lyndon Johnson got to the Senate in 48. And famously, Lyndon's lawyer at the time, who later got to the Supreme Court, Abe Fortas, was able to leapfrog the various appellates to get Hugo Black to make a decision, very quickly to basically save his candidacy. So, yeah, it's completely possible. And hopefully that'll happen. Gee whiz, Mark. I mean, this is such a deep subject. It's so fun. I think the most misunderstood part of our history is really Reconstruction. And I recommend people to read W.E.B. Du Bois' Reconstruction in America. That was an eye-opening experience for me, to understand those moments, because, growing up, my understanding of Reconstruction, I mean, all you had to do was watch Gone with the Wind or, any number of movies, that this was a period that was chaotic and horrible, when in fact, it really is one of the most hopeful moments in our history when, like you say, the Freedmen's Bureau and these amendments were crafted. They're quite brilliant, in their construction, and they're the foundation for everything that's happened that's we can kind of attribute to social progress. So I feel like there's a big hole in our understanding of that, of not only the promise of Reconstruction, but the tragedy of it, because ultimately, those gains were in effect lost, with Jim Crow and voting rights. And it wasn't until the span of my own or our own lifetimes that we could see sort of, these things actually take effect. So you're doing important work, and I'm hopeful. I don't know, what could I do, or what can a citizen do to help, bring this section into focus? Because I feel most people don't have a clue about it or aren't really aware of it.
Section into focus. I think there is good scholarly work, and more of it should be encouraged, on bringing Reconstruction into focus. That the Reconstruction Republicans were not radicals gone wild, but people committed to tearing down a variety of status hierarchies in the United States, and not simply race. That if they ought not to replace James Madison, George Washington, they ought to be on the same pedestal. And so it's our job, my job, in the weeds. It's what I get paid to do, to go read every newspaper report in Connecticut that talks about the 14th Amendment and report on what is said. And then for people who do, media, to, pay attention. You're giving me an hour, which I am so grateful for. I like to say, making academics talk is easy. Making us shut up is a little harder. Just when we tell the story, tell, Thaddeus Stevens, Charles Sumner, John Bingham as American heroes who we ought to celebrate for their commitment to union, democracy, racial equality, and other things we've now come to recognize are good democratic things.
And Frederick Douglass, to me, is kind of like, I don't know, he's like, in many ways, to me, like the most important person of the 19th century. His journey from slavery into even to abolition, to the government, it's just an incredible journey. And to me, he's the one who in a way, and probably Thaddeus Stevens, that can actually kind of see over the horizon to this hopeful possibility of a multicultural democracy, when very few, of my view, at that moment really could envision that. So I always like to add him to the.
We should also add, as a friend is doing a project, there are a great many African American political conventions and women political convention. How do they understand the Civil War amendments? After all, if the understanding ought to be what ordinary people understood, they're ordinary people too.
Yeah, maybe what was it, Hiram Revels, and I think one of the most misunderstood, at least as I understood it when I read W.E.B. Du Bois, was that black suffrage during Reconstruction was huge. It wasn't like there was a tremendous desire among recently freed people to participate and to vote. There was not. It was not disinterest and apathy. Actually, as I understand it from what I read, it was entirely the opposite.
Yep. No, a lot of African Americans being elected, speaking in Congress, being involved in Congress, speaking locally. This was not a time of great political corruption. If anything, if one looks, as Du Bois points out, this was a time where you actually started to have public education, public resources in the South.
Right. And then one other thing, when I was reading about the Freedmen's Bureau, that sort of in a small way anticipates what the New Deal would be, many decades later, because it's the first time where you see like a federal effort to improve the lives of citizens. And so there's so much that happens there in law and in practice that I just think is so important to understand the present moment, because so much to me of the 1960s is sort of this pent up demand from the promises of Reconstruction that were delayed. So this
second Reconstruction, the third founding.
What's that? The second Reconstruction, the 1960s, yeah. Right?
I apologize. I just need to check. Okay, I know what this is. My car is ready.
Okay, good. Well, that is my cue. I feel like a very gracious and eager graduate student who got some, office hours.
Well, I'm just grateful for the opportunity to talk.
Well, I'm grateful for the opportunity to listen, and I hope maybe there's a time where we can maybe do an update on this, because this intersection of constitution and real world politics is interesting, and I just think there's an obligation for the citizenry to go, wait, this is in the Constitution. Wait, look, because very often the political players respond to the people shouting outside the courthouse. So I'm doing my best. What can I say?
You know the email address.
What's that?
You know the email address.
Right, I absolutely do.
You know the phone number. Now it's the email address.
I don't know the phone number, but the email's enough. And I'm going to post this, and people can watch it, and hopefully there's some awareness that will be raised. And Mark Graber from Silver Springs, Maryland, I want to thank you for your incredible scholarship, the thought that you've put into this, and how what at once seemed like an arcane backwater little section of the 14th Amendment is now, is ready for its big time close up in the 21st century. And you're really an important actor in that movie. So thank you for everything.
Thank you for having me.
Okay. So folks, until next time, namaste, shalom, and aloha. By that I mean namashaloha, and a belated happy Hanukkah to everybody else. And till next time, I'll see you.